Start. All right, everyone. So happy summer. This is our June 2025 Lunch and Learn focused on the Delaware Sex Offender Registry. Always an interesting topic, and I'm really excited to have Kristina Bensley from Department of Justice joining us, as well as our own very own Kelly Ensslin from Office of the Child Advocate. But Kristina is going to kind of take it away. So, Kristina, can you introduce yourself to us and who you are, and then jump right on into it?
Yeah, sure. So, as Lauren said, my name is Kristina Bensley. I am a criminal prosecutor with the Delaware Department of Justice. I've been doing that for about 7 years now. But for the last year and a half, I have served as commander of the Delaware Internet Crimes Against Children Task Force, also known as the Child Predator Task Force. And so Lauren and Kelly invited me to talk about Delaware sex offender tiering and registration requirements because prior to this job, I did serve in the Special Victims Unit, and part of my job in the Special Victims Unit was also to assist with the tiering of sex offenders and kind of filing of the registration motions and the risk assessment motions. And so we know that that has a effect on what you guys do as CASAs, and you might need to consider that information when you're doing your jobs. And so I'm going to talk a bit today about what that process looks like, all the requirements, and then Kelly is also going to talk about the presumption of sex offenders and custody. Okay. All right, so unless there are any questions at the outset, I'm just going to get started. Can everybody see my PowerPoint presentation okay? Okay, perfect. All right, so we will get started. So the purpose of sex offender tiering is to assess the risk of a sex offender and to protect public safety, obviously. The legal basis for that is that it's actually codified in Delaware in the 11 Delaware Code 4120 through 4121. And that sets apart all of the instructions for how sex offenders are registered, their requirements for registration, their requirements for reporting, and what the tiers are. And so there are actually 3 risk assessment tiers. There's the low risk tier, the moderate risk tier, and the high risk tier. So tiers 1, 2, and 3. And so the process by which sex offenders are tiered is that they are assigned to their tier based on their criminal conviction. Now, the code has some fancy language in it about based on a risk assessment, and really the risk assessment is what crime they were convicted of. And it's set apart in the statute based on the crime they were convicted of, what tier they're assigned to. So once they're assigned to their tier based on their criminal conviction, a notification gets sent to the Delaware State Police and local law enforcement based on where the person lives as to what their tier is. The sex offender registry is managed by the State Bureau of Identification, or SBI, you guys might know it as. So they actually are the ones that monitor the sex offenders and do all of the registration requirements and things like that. So when it says verification in person, for instance, it means in person at the State Bureau of Identification offices. And so that's kind of who oversees it from the law enforcement perspective. So as I was saying, 11 Delaware Code 4121 is where it lists the convictions that are assigned to each risk assessment tier. There's a little bit of a cheat sheet in the CENTAC bench book, which is the sentencing guidelines. And that is a publicly available document that you can access. This is what the front of the bench book looks like. And if I am able to screen share properly, which is always questionable, you can actually see. So Sentencing Accountability Commission has a website that's posted right there. It's posted in the slides and I'll send those slides out so that you guys can access them. And then there's a bench book. It's the 2025 bench book. And so that has all of the sex offender registration, what the tiers mean, what crimes are assigned to each tier. It's a really good resource to just one-stop shop. You don't have to read any legal language in the code to try to figure out exactly what tier someone might be assigned to. So that's a good resource. So going back to the presentation, we're going to start with the highest tier and go to the lowest tier. So, and there's a reason for that. So the highest tier is tier 3. It's the high risk tier. Their registration duration is lifetime registration. And they have to verify in person every 90 days at SBI. If they are homeless, they have to verify in person every 7 days. And when they do that, they have to give an area of Delaware in which they usually are when they're homeless. So they don't have an address to give, but they do have to verify if they're working, where they work, and they also have to verify where they in what general area they typically are. Tier 3 offenders are on GPS monitoring by default. They are monitored by probation on GPS monitoring, so they do have a monitor on them. It does cost money, and it is the requirement of the offender to pay that fee for maintaining the GPS monitor. Tier 3 offenders can petition for a Tier 2 after 25 years if they've undergone treatment and they've had no new convictions. If they pick up an additional conviction, that 25 years starts over at the date of their new conviction. So they have to stay without any criminal convictions for 25 years before they can petition to be flown down to a Tier 2. You cannot go directly from a Tier 3 off the registry after 25 years, but you can petition to flow down to a Tier 2, which would be a lower risk category. So this is directly from the CENTAC bench book. This is the tiers, the Tier 3 assessment and what criminal convictions will qualify you as a Tier 3 offender. So you can see it's the most serious of the sex crimes, with rape first degree, rape second degree. It does have the old versions of the rape statutes that we previously had and when they were repealed. And it also, as you can see, has a list of crimes that if someone is convicted of that crime and upon motion of the state, if the victim has not reached their 16th birthday and the court determines that they belong in a higher tier, there is some discretion there for the state to ask for them to be assigned to the Tier 3 risk assessment category, even if they were not convicted of an automatic Tier 3 conviction. So there is an option there for that. The second tier is the moderate risk category, or intermediate risk. The registration duration for that is 25 years. They have to verify in person every 6 months. And if they're homeless, they have to verify in person every 30 days. Tier 2 offenders can petition for Tier 1 after 10 years if they've undergone their treatment, the victim is not under the age of 18, and they've had no new convictions. So that's kind of an important distinction there. A Tier 3 offender can be reduced to a Tier 2 offender, but a Tier 2 cannot reduce to a Tier 1 if their victim was under the age of 18. So there's obviously a lot of sex crimes that you can commit against adults and some specific to children. If you are a sex offender that committed a sex crime against a child, you will always stay on the Tier 2 category. You will not be able to flow down to Tier 1. Another important distinction for that is that this counts even for crimes where there is not a, quote, live or in-person victim, meaning the crimes that I prosecute are internet crimes against children, which involve possessing or exchanging child sexual abuse material, so images and videos of children. Those people can also not flow down to Tier 1. That was actually a recent decision that was made in the court, that even though there's no, even if we have not identified that victim, because it is quite common that we do not know exactly who that child is in the image or the video. They are a child, and because they are a child, those offenders cannot flow down to Tier 1, regardless of the fact that they have not committed a contact crime. Here's the list of the Tier 2 assessment criminal convictions. Again, kind of the intermediate side of the sex crimes. Rape third and fourth, extortion, dangerous crime against a child, and then you see the child pornography offenses and sexual solicitation of a child. And then again, another set of crimes that if convicted of those crimes and the state makes a motion to the sentencing court, they can be elevated to a Tier 1 when they would normally be, or a Tier 2 when they would normally be a lower tier. And then finally, we have the Tier 1, which is the low risk category. Their registration duration is 15 years. They have to verify in person once a year. And if they're homeless, they have to verify in person every 90 days. They may petition for relief from the registry, so they can be removed from the registry after 10 years if they're eligible. And again, that means that they haven't had any convictions and that they've undergone their treatment and that type of thing. You'll notice that there really isn't, besides maxing out the time by which that you've been in a certain category, there isn't an automatic off of the registry for the Tier 3 and Tier 2 offenders. They have to flow down, and then they can be removed. They don't get automatically removed unless they've maxed out their timeline. So if a Tier 2 offender has been on the registry for 25 years, they are removed after 25 years. But if it's been, 15 years by which they're able to be like reassessed. They cannot go immediately off. They have to go to tier 1 first. And here's the list of the tier 1 assessment crimes. Again, you'll probably recognize this list from the ones that could be elevated to tier 2 if applied by the state to the sentencing court. You'll note that also this mentions that if you are convicted for a tier 2 offense twice, so if you're a tier 2 offender and you're convicted of another tier 2 offense, you will be designated to tier 3. So you do get upgraded if you commit another sex offense. And again, convictions for subsequent tier 1 offenses within 5 years, you will be elevated to a tier 2 for the second conviction. And there is a note down here too that if a sex offender is placed in a wanted person status, they will be raised to tier level 3 until they have been reduced, until they have cleared their warrant or their capias, and then they will be reduced back to their original tier. So there are some things in place to make sure that people are not being wanted and that they're being more accurately watched. So the process for tiering actually begins like 45 to 90 days before their release or at their sentencing if they're just being sentenced to probation. So if someone is going into custody, if they're staying at level 5 incarceration, they're actually not going to be placed on the registry until they are released from custody. So that tends to confuse people because they've been convicted and they're beginning their sentence, and people expect they're going to be able to go on the registry and look that person up right away. That's not accurate. They're not going to be on the registry until they're being released from level 5. And that's because there are a lot of people on the sex offender registry, and it would be very difficult to monitor and kind of pointless to monitor sex offenders when they're being incarcerated. There's no sense. They don't have to register yet. They don't need to be tracked. We know where they are. And so they're not required to actually register until they're being released. They do send some forms to the Delaware State Police. And then they have information on the offender, including their name, aliases, their date of birth, what address they live at, the vehicles, their school. They do take their DNA and they take a photograph of them. Address changes have to be reported to the SBI within 3 business days. So if a sex offender changes their address, they do have to re-verify. Obviously, they have a frequency based on their tier for how often they need to verify. And they do pay some fees. They have to get their photo taken, their fingerprints, and all their records need to be updated. So community notification. Only tiers 2 and 3 are community notification tiers. That means that if someone is a tier 1 sex offender, the only access to that record is going to be for law enforcement. So law enforcement will always know that someone is a tier 1 sex offender, but they are not going to be listed on the public website. So you will not find a tier 1 offender's information on the public-facing sex offender registry. They are flagged as a tier 1 offender, and like I said, law enforcement can access that. I can access that as a prosecutor. Police officers can access that, and it will come up if someone does a background check on them. However, it will not be a public-facing information, so it will not be on the website. Tiers 2 and 3 are listed on the Delaware Sex Offender Registry and also on the National Sex Offender Registry. The only difference between tier 2 and 3 for notification is that sometimes for tier 3 offenders, they kind of can go door to door or provide a mail notification that a tier 3 sex offender is moving into into a residential area. Sometimes for tier 2, they will notify schools or daycares that someone is moving in, but tier 3 offenders is where you might see like a typical door to door or mail notification for a sex offender. Sex offenders are prohibited from living or loitering within 50 feet of the property of a school. A school is defined by the statute to mean any preschool, kindergarten, elementary school, secondary school, vocational school, or any other institution which has its primary purpose the education or instruction of children under the age of 16. That's an important distinction because daycares do not qualify as a school unless they are for the primary purpose, the education or instruction of children. So if it is an educational daycare where they are receiving like a curriculum of education while they're at daycare, then that qualifies as a school. But normal daycares where the only or the primary purpose is just taking care of children, caring for children, that does not qualify as a school. So a sex offender would be able to live within 500 feet of a daycare. So that's something just to be aware of. However, residing or loitering in a school zone as a sex offender is a Class G felony. So if we find that a sex offender is living within 500 feet of a school or is loitering within 500 feet of a school, they can be charged with a felony. There is a note in the code as well that lack of knowledge that you live near a school is not a defense to this. So they have to be aware of their surroundings. They can't claim they didn't know there was a school within 500 feet. Like we talked about before, they can petition to be relieved from the registry. That's from Tier 3 to Tier 2 after 25 years, treatment and no new convictions. From Tier 2 to Tier 1 after 10 years, a victim not under the age of 18, treatment and no new convictions. And then from Tier 1 to relief from the registry after 10 years, treatment and no new convictions. Superior Court also must find that the public safety no longer requires the designation. They typically do find that if someone has been on the registry for 25 years and they have not committed another crime, it's kind of hard for the court to say that they require to be designated that way any longer. And the way that usually works is that the offender will petition the court and they will file a motion with the court petitioning for relief. The state does have an opportunity to respond to that. And usually on our end, what we're doing is verifying that they've got no new convictions, that they have done their treatment, that their victim is not under the age of 18, and that the timing works out properly. And then we typically will not oppose that redesignation if they have followed all of the requirements. There are penalties for noncompliance with the registry. Failure to register or comply with the registration requirements is a Class G felony. People are frequently charged with failure to register or other crimes for not keeping up with their registration. So a warrant gets issued for them and then prosecution may follow. Sometimes it's just a matter of the warrant being issued and then realizing that the person eventually did register. They just registered a couple days late or something, and then we sometimes will let that go. It just depends on how often someone has forgotten to register or missed their deadline with the with SBI, but we do kind of prosecute those on a case-by-case basis. There is a process also for out-of-state offenders. So if a sex offender moves into Delaware, and they're registered in whatever state they came from, typically a nearby state, but sometimes from further away, but we get the most transfers from Pennsylvania, Maryland, and New Jersey because they're close by. So if they're registered in their state, their state will notify our state that the sex offender is moving into the jurisdiction. So the Department of Justice will be notified usually by the Delaware State Police that someone is being transferred to Delaware and they need to be re-tiered in Delaware. So they get temporarily assigned to Tier 1 until they can be tiered properly by the court. DOJ then compares their out-of-state conviction with Delaware statute and chooses the comparable crime. So we will look at what they were charged with and convicted of in PA, New Jersey, Maryland, and we will find the comparable crime in Delaware that they would have been convicted of in Delaware. And then we choose that risk assessment tier. This process is required by statute, and it actually says the Attorney General or the court must file a risk assessment motion in Superior Court to assign their offender to the proper tier. We then present the motion. We actually file a motion for risk assessment, and we present the motion to the court. The offender does have the opportunity to oppose the motion, but I will say that neither the court or the DOJ have any discretion to recommend a different tier than the one that is assigned to the crime that they've committed. It comes up pretty frequently that the offender who moved from a different state feels that they are being assigned to too high of a tier in Delaware because they are not assigned to that high of a tier in their own state. Even if that's the case, the Department of Justice nor the court has any discretion except to assign them to the tier by which their crime is assigned. And so the only discretion we have is in choosing the crime that is comparable to the crime they've been convicted of out of state. We have no discretion otherwise. I just wanted to mention SORNA really quickly. That's the Sex Offender Registration Notification Act, the federal Sex Offender Notification Act. SORNA provides a set of minimum standards for sex offender registration throughout the United States. They have a website, which I will bring up to share with you. And if you go to this website, you can actually see what states are complying substantially with the standards and what states are not. And you can also get a link to each individual sex offender registry site. I will say I will note that Delaware does substantially comply with SORNA. So every year they evaluate us and they issue a letter saying, you are substantially compliant with SORNA. And so let me change the sharing here. So here's the sex offender or the SORNA website. You can see that here's a map of the United States, and you can actually click on any state and it will tell you whether or not it is compliant. There's also marked by green and gray. You can see that a substantial amount of the United States is actually not compliant with SORNA. And what that does is it may affect some federal funding or other type of support that we receive from the federal government. It's not, they're standards, they're not requirements. So it's not like a federal law that we have to be compliant with SORNA, but it is recommended. And you can see that Maryland is the only one that borders us that is compliant with SORNA. And because of that, offenders from Maryland who come to Delaware or vice versa have a pretty easy transition process because the tiers are probably pretty similar. But Pennsylvania and New Jersey, they don't have the same tiering process as Delaware. So someone who is a tier 2 offender in Pennsylvania might be a tier 1 offender in Delaware, or vice versa. They might be a tier 1 offender in Pennsylvania and a tier 2 offender in Delaware. And so that can cause a little bit of confusion, especially on the offender's behalf, because they think that they're moving into a state and they're going to stay with the same requirements, but each state actually has different requirements depending on their statute. So you can, if you click on Delaware, down here it will say substantially implemented SORNA. There's a link to the implementation review and also a link to the registry site. So if you click on any of the other states, again, it will tell you registry site implementation review. So you can actually read and go to each one. So just the key takeaways about the registry is that the tier essentially determines the duration, the verification, and the notification. Registration begins either like when they're being released from custody or at sentencing if they're on probation. They can be relieved from the registry if they're under certain conditions, and that they do have serious consequences for not complying. I do just want to show you guys the sex offender registry for Delaware and just the National Sex Offender Registry, just so you kind of know what it looks like, and you're kind of able to look that stuff up. So we'll go back to here. And this is what the Delaware Sex Offender Registry looks like. You can type in the last name and the first name of the offender that you're looking for and hit search, and it will bring the person up. I actually can probably use someone who I know is registered. So it brings up their photograph. You can click on their name and it will tell you what tier they are, when they were verified, when they've been registered since, whether they're currently in prison. So it looks like this person is incarcerated, but maybe not for a sex offense, like he was picked up on something else. Right now it looks like his verification address is JTVCC, so he's at James Vaughn. And then it shows you exactly what he was convicted of and the date that he was convicted of that. If they are convicted of a crime, of a contact crime, it will tell you what the victim's age is, and it will tell you what state they were convicted of if they were convicted in a different state. So that's what the Delaware registry looks like. You can also click to submit a tip about the offender, or print it out if you feel like you need to. It also gives all their biographical information, if they have any tattoos, that kind of thing. So you could also do the same thing on the federal sex offender registry website. So you can search by name or location. So we'll use the same person, do a name search, and make sure that you're doing your terms and conditions. So it looks like here's this person, Brahim Kelly. You would click on them and it would bring you to the Delaware website. So they don't have a separate registry website, but they will link you to whatever website the person lives in. So you can see, and it also obviously is a keyword search, so it's going to bring up people here. I tend to search, if I know somebody that I'm looking for, I tend to search on the national website because people move between states. So even if they were a Delaware resident when they were convicted, they may not live in Delaware anymore. And if you do that, if you type someone's name into the Delaware registry and they were convicted in Delaware, but they don't live in Delaware, they will not come up with any results because they are not on the Delaware Sex Offender Registry. So I tend to start with the national registry and then go through from there. So that's the Delaware Registry, and I also included the link to the National Registry on there as well. And then at this point, I believe I'm going to turn it over to Kelly. She has some information to share about how there's a presumption that that children should not be housed with sex offenders, and how that kind of affects your jobs.
But I don't know if you want, Lauren, how you want to handle this, if you want people to ask questions of Kristina now or just wait till the end.
Yeah, you know what? If it's okay, if this feels like kind of a natural pause, I think we've got at least one question in the chat that goes back just a little bit. I just didn't want to interrupt anything.
Yeah,
Christina, is it okay if we take a little pause for questions?
absolutely.
Okay, so all Casas, I'll ask at least the one that I see in the chat, and if anybody else has other questions, feel free to raise your hand and I can kind of monitor that way. But one of the questions, kind of going back a little bit about the different sex offenses, was about female genital mutilation. Seems really violent. Why that wouldn't be on a higher tier. And really, the questions are probably also like, how does each offense determine, how did each one get on each particular tier?
Sure. So it's in the statute. I can actually pull up a statute for you. And so the legislature essentially determined what offenses should qualify for each risk assessment tier. Female genital mutilation, I think, when you hear that, you might be thinking that someone is mutilating a female's genitals, like as an older child or an adult. But really, I think that's like sort of like the male circumcision type thing. Like it's, and as a child, it's a thing where we kind of decided, I guess, at some point that the religious requirements of some cultures where they would, mutilate genitals in some way, was unacceptable. And so we included that in our tier. So it's not a typical sex crime. It's not like someone who's older, like an adult, mutilating another adult. It's really meant for that kind of baseline where we decided like this was an unacceptable practice in the United States, and in our state. And so that's why it was incorporated. So if someone, an adult mutilates another adult or mutilates an older child for any reason, whether it's an assault or otherwise, there is a host of other charges that someone would be charged with: assault, other things depending, and they would have some pretty serious consequences. But I think as far as whether or not someone is likely to reoffend or is a danger to public safety as a sex offender, I think that's probably why it was included in a lower tier, because it's not a typical contact crime the way you would think of someone who's molesting a child or something along those lines. So that's my guess. If you were really interested in what the legislature was thinking, you could probably look up when that was made illegal and what the legislature's comments was on why they chose that particular statute or why they assessed it in that particular category. But that's my educated guess.
Awesome, Christina. Thank you. And any other question that has to do with why particular, crimes are listed as particular tiers, that's all up to the legislature. So any questions there, I'm just going to kind of direct us to our legislators to ask, why they were put in that particular area.
Yeah, it's based on the statute. And luckily, if there's something that happens, like you saw, based on the slides, that there is a certain section of crimes that are specifically assigned to each tier, but then there's a second set of crimes that you can elevate to a higher tier if warranted. So even if you feel that if a prosecutor felt that a particular case, even if they don't meet the tier 3 automatic registration requirements, that case elevates them. So for instance, maybe they're convicted of a tier 2 offense based on a plea agreement or something similar, but really the overall case was much more violent or much more serious. As long as it met those standards, the state could motion to raise them up to a different tier. So there is some discretion at that level to be able to decide what tier someone should be assigned to, and that's somewhat also can maybe be negotiated between the parties. But the part where we don't have discretion is someone moving from out of state into our state. But we have some discretion on the front end of someone who's being convicted in Delaware as to what tier they should be assigned to. I will note that we cannot lower someone's tier. So if someone is convicted of sexual solicitation of a child, we can't ask for them to be tiered as a tier 1 offender. They have to be tier 2 or above. We can't go lower, but we can go higher if necessary.
Awesome. Thank you for that. Any other questions that I see?
Yes.
Go for it, Beverly.
Okay. Christina, you said that tier 1, that only you and maybe law enforcement are able to access those offenders on tier one, and the public can access tier two and three. Now, when DFS makes a request to find out whether sex offenders are in a potential home, what information is shared? Is it tier two and tier three, or is tier one shared also? Thank you.
That's a good question. I actually don't know the answer to that because I don't know where DFS gets their information from, but I have a feeling Kelly knows the answer to that.
Yeah, so DFS gets their information from Delgis, or they do so Delgis would be our, internal Delaware. So if the person was charged in Delaware, even if they weren't convicted, that would be on the Delgis report, and you would know that. They we cannot run we can run Delgis. We cannot run NCIC, which is like the national search. So if somebody is convicted of a lower sex crime that doesn't need to be reported to Delaware, but now they're living in Delaware, the NCIC would pick up on those charges, but only DFS can run that. So we sort of have to rely on asking DFS, did you do an NCIC? Is there anything we should be concerned about? So that's kind of how that goes.
Would
Yeah,
DFS share that with us?
They,
Or
yeah, they definitely should.
okay.
Yeah, if I know, like when we run Delgis, you can usually tell if there's other charges from other states, because if there's an FBI number, then that's like our clue, like, maybe there's something out of state. So that's when the attorney or your coordinator or you can ask DFS, hey, did you run an NCIC on this person? It looks like maybe they have out of state charges. They won't like print it and give it to you or anything, but they should be able to tell you, yes, we ran it and this is what we found. You can also try just Googling the person. I found that Delaware's doesn't do this, but a lot of states do publish like arrests, convictions too, but sometimes just arrests. Sometimes you just Google somebody and you find out like in Maryland or Virginia, they got charged with something and it's on their state's website. It could be a news article as well, but I know Maryland and Virginia are two that stick out in my mind as ones that will post, mugshots and charges. So sometimes you can find them that way.
yeah, and
Thank you.
I think
Oh,
that one flag you might be able to pay attention to is that even if the charges themselves aren't in Delgis from a different state, theoretically, if someone is moving into Delaware who is a sex offender, they will automatically place them on that tier one registry hold until they are elevated to their actual tier. So it should say registered sex offender with tier number one on their Delgis. So for instance, I'll pull up what it looks like. And again, because of the timing, it's possible that there might be some that don't transfer over right away, or that hasn't been updated in the system. But I'll show you just like briefly what that looks like without sharing too much information about this person who you've already seen. But you see under other offender status, it says registered sex offender with tier number two. So that should theoretically show up as soon as the person has transferred their information from the state they were in to Delaware. Theoretically, it should then show us that they are at least a registered sex offender. It's not going to show what charges or what maybe the appropriate tier is if he hasn't been appropriately tiered yet, but it will at least maybe flag for DFS or for law enforcement that this is a sex offender.
Yeah. Assuming they moved into Delaware,
Correct.
registered themselves, and aren't like
Yeah.
on the run or something, obviously.
Assuming they're not like on the run from a different state or something.
Yeah.
Because this also obviously requires that they notified their state that they were moving, and then their state notified Delaware that they were moving, and then the whole thing has to kind of connect together. So there definitely will be situations where that might not happen.
thank you. Very interesting.
I also wanted to point out that a lot of the times in our DFS cases, we're concerned about people that are not parties to the proceeding, right? We're worried about mom's boyfriend or the uncle or what, and we cannot run Delgis on non-parties. So that's when, like, you looking at the National Sex Offender Registry, Googling their name, things like that can be really helpful. again, DFS can run it, but we have to rely on them to do that and report it to us. So I always like to do like a little extra check if I'm worried about mom's boyfriend, just Googling their name, looking on the sex offender registry, making sure there's nothing public and obvious that we should know about, and then
Uh-huh.
going to DFS and saying, hey, this guy's living in the home. Is there anything that we should be concerned about from his criminal background?
Very interesting. That's a bit of a gap, isn't it?
It is a little bit of a gap, yeah.
I'm
Um,
glad we have something anyway for to
Yeah.
know. And I'm glad DOJ manages this so well.
Christina, we have another question in our chat, and I'm trying to be clear about it's kind of a two-part question. And this particular CASA is a nurse, a pediatric nurse. And she says that sometimes kids are admitted to, I'm guessing the hospital or the office with a parent who's on who's on the registry. And shouldn't DFS be required to tell the I think it means that like the hospital staff. And our second question would be, are offenders even allowed on a pediatric unit in a hospital?
There's nothing that would allow them not to be unless they are still on probation and that their probation conditions require them to have no contact with children or something along those lines, which if that were the case, then they shouldn't, unless there's a specific caveat, they shouldn't be with their own child. And that's, I guess, an important distinction that I didn't mention previously is that when sex offenders are on probation, they may have more serious conditions they have to follow because that's part of their probation conditions. The conditions that sex offenders have after they're off of probation and just on the registry are a lot less because it's just the registry they're on at that point. They are not on probation. So they aren't required to have no contact with any children or no contact with a specific place or anything like that. The only designation or the only requirement that they or no contact that they really have is with not living or loitering within a school zone, and a hospital doesn't count as a school zone. So they wouldn't be prohibited from being in that kind of environment unless they were on probation and their probation conditions specifically say that they are to have no contact with children or something along those lines. And I, as far as whether or not they should or are required to notify or whether DFS should notify them, I'm not sure I can answer that, unfortunately.
Thank you.
Yeah, of course.
Any other CASA questions? I don't see any in the chat, and I don't think we have any more. So,
Okay.
Christina, yeah, sorry.
We can forward to my slide then.
Yeah, and then you can just let me know when you want to switch slides.
Yep. Thank you. Christina did, and thank you very much. We're lucky to have an expert on all of this. And she covered sort of that criminal piece. So I'm going to move into the civil piece of all of this. So Title 13 is generally where most of our laws for our DFS cases lie. And this is no exception. So we do have a statute that is called Child Protection from Sex Offenders Act. There also within the same chapter is the Child Protection from Domestic Offenders Act, which is similar but separate. I'm only going to talk about the Sex Offenders Act today. But I just kind of put the statute up there so you could read along a little bit. But basically the purpose is we're coming in, we're coming into the protection of children thinking, okay, if you're already a sex offender, this is something we need to be concerned about. So we're presuming that it's not in a child's best interest to be placed with, have unsupervised visitation with a sex offender. That is, and for definition purposes, sex offender is a tier 2 or tier 3. So again, those tier 1 people do not fit into this. But if they are a tier 2 or tier 3 sex offender, our law has a presumption that precludes children from being placed with them without, and we're going to go on and see what has to be done. So you can switch slides for me, please. Oh. Okay, so this is the rebuttable presumption. So not withstanding other provisions, there is a rebuttable presumption that they will not be awarded sole or joint custody of any child, and that a child should not primarily reside with a sex offender, and they should not have unsupervised visitation with a child. So that is in our DFS cases, but it's also in private custody cases. So it's interesting because when someone becomes let's say the person already has children, they're married, um, and the parents get divorced, and the mom and dad just agree on a custody arrangement, right? It's not before the court, um, and they just have this arrangement. Without the court involvement, none of this really comes into play. It's not like somebody swooping in and saying, hey, unless, again, going back to what Kristina said about being on probation and them having some sort of restrictions with probation. But if they are, allowed to have contact with their own children, and that's the agreement the parents came up with, this statute wouldn't come into play. However, if mother goes and files for sole custody or even to get a joint custody arrangement, on as a court order, then the court, knowing this information, has to consider this presumption. So we have had cases where, that has happened, where DFS has kind of come in to investigate, don't have any specific concerns regarding sex abuse, but find out that the parent that, let's say father, just because that's the most common, was a tier 2 or tier 3 sex offender. Without the court involvement, this actually doesn't even come into play. And there's actually a court case and case law on this where DFS tried to take custody of a child because the only parent that could care for the children was this sex offender. And the children had been living there for years alone. And they filed for custody because it became known to them through through a DFS report, again, that had nothing to do with sex abuse. And the court said that you can't just bring this to us as a concern without a custody petition, and they said DFS did not have grounds to file for custody of the children based solely on that sex offender status. So there's a little bit of back and forth within the courts about whether that would apply or not. However, if the child is in DFS custody for whatever reason, this statute is going to apply. So you can flip to the next slide so I can tell you when that can be overcome. So let's assume that the children are in DFS custody, that we find out that dad is a tier 2 sex offender. He can overcome the presumption and have either unsupervised visitation or custody of his children, but there are, as you can see, quite a few steps, and these are all ands. So he has to do all of these things, and it has to be in the child's best interest. So there can't be a criminal sentencing order that prohibits, obviously, again, going back to like if there's a no contact order in place, for instance, then we can't place. There can be no further sex offenses or criminal acts of violence. So it's not just sex offenses. If there was a physical assault of another person, and it doesn't have to be a child either. The sex offender, it has to be in compliance with probation if they're on probation. And they have to successfully complete an intensive program of evaluation and counseling designed specifically for sex offenders and conducted by a public or private agency or certified mental health professional. And that person has to be able to say that this person, in my expert opinion, does not pose a risk to children. So that's probably the hardest part for the person to overcome. They may complete a program, but they have to have an expert say, yeah, this person isn't a risk. And that has happened. And then the sex offender also has to complete a program of substance abuse counseling if the court determines that is appropriate. At some point in the drafting of this legislation, it was decided that there might be some connection between the substance abuse and sex offenses. So that was in there as well. And then, of course, it has to be in the child's best interest for the to give residential or custodial responsibility to, or visitation to that sex offender. So there's a lot of protections in place, and the sex offender, it doesn't matter if their victim was a child or an adult, just them being on the registry is what kind of implicates this statute.
Kelly, do you mind if I pause for, because there's a question that applies directly to this?
Sure.
So does this apply to sexually abusing their own children like when the parent abused their own children, and then can they overcome the presumption to live with their own child if their child was the victim?
Yes and yes. It
Okay.
does apply to sexually abusing their own child, and they can overcome the presumption. Obviously, I think we can all see where that would be a lot more difficult for the court to find it's in their best interest that this person sexually abused them, and now we're going to place them with them or be unsupervised with them. I can't think of any situation where that happened, but they could technically per the statute. Any other questions about that presumption?
I kind of have an off the cuff question, Kelly, but do we think that, like in your experience in child welfare, how often or how frequent do sex offense cases kind of come to through the Office of Child Advocate?
Yeah, if we're looking at like the reasons children enter care, uh, entering care because of sex abuse is pretty low, a very low percentage. I'm not saying there's a lot of sex abuse going on, unfortunately. I'd like to say that's because it's not happening. It's happening, but a lot of the times DFS gets involved, but a parent is protective or they can place with a relative. But kids coming actually into DFS custody because of sexual abuse, the percentage is pretty low. I think it's a lot more common where we're finding that the children are coming in for whatever reason and they have been sexually abused, or someone, in the past, or that somebody that wants custody or visitation with them, is a sex offender. That's when it comes in more into play for us in our cases, I think.
Gotcha. Thank you.
And the domestic violence presumption, I think, is a lot more common when we're looking at this chapter of statutes. Our DFS cases usually a much higher percentage are going to involve a presumption that needs to be overcome because of being a domestic offender. Now, I did want to mention, because it's only for tier 2 and tier 3 sex offenders, just because someone is a tier 1 sex offender or maybe never even convicted, but we know they were charged, or reading the DFS records, we're seeing all of these concerns or hotline reports of sex abuse, we can still use that information as part of our best interest analysis with the court. So it's not like, oh, that doesn't exist because they're tier 1, or it doesn't exist because they weren't convicted or substantiated. We can still, use that evidence to bring to the court as a reason to, not place with someone or not allow unsupervised visitation because we have these concerns. I'm not saying the judge would necessarily always agree with us, but that would definitely be evidence we would want to present regardless of whether they're a registered sex offender or not.
Awesome. Thank you. Casas, any other questions? If not, oh, Devin, go for it.
Hi, and so sorry if you already addressed this. I got pulled away for a quick work call, but what if you have a tier 2 sex offender who it says that they're homeless but they're always in the home when there's any visit by DFS or CASA, and they have an active case that they haven't overcome things yet, right? Like that hasn't been because I have been surprised in my own case, it was not the it was related tangentially to my case, because it was considered a placement that we were looking at, and but there were two active cases going on in that home, um, that I was not the CASA on. And I'm just interested, like, I just don't know what, like, I brought that up. I said, like, if he says he's homeless, but he's always here and he is always sleeping here, then isn't this an address that he should be? But so I don't know. What is the course of action that should happen? I told enough people that I felt like somebody would have done something, but I didn't know, like, what is the course of action with that? What is supposed to happen in cases like that?
I would say the course of action is to call the police, because they
Okay.
are actually violating the law and their registration requirements by not actually accurately reporting where they're living and where they're staying. There's two ways you can do that. You can either actually just call the police. You could call them
Hmm.
a non-emergency number if you feel it's not something that needs to be a 911 call. Or I don't know if you were on the call or not when I showed it, but on the sex offender registry, if they're a tier 2 offender or a tier 3 offender and they're on the public facing registry, under their photo, when you go to their profile, it says submit a tip about this offender. And you could actually submit a tip saying, like, this person is reporting as homeless, but I am aware that they are actually staying at this residence. There is a calculation that is done, and it's statutory. You can find it in either the 4120 or 4121 notification requirements as to what is considered a residence for someone, like how often they have to be basically staying there. And I will also note that even if they don't live in Delaware, people who work in Delaware also have to report to the sex offender registry. You are registered either if you work or live in Delaware, so you reside there or work there. And it has come up a few times where people for work, they are like truck drivers or something, and they travel through the state enough that they actually have to
Hmm.
register on the sex offender registry because they're in the state for work enough that it qualifies. So
Hmm.
you can pull that up in the statute. There's actually, it says how many days out of the month or out of the year they have to be actually residing in that place. But my suggestion would be to either submit a tip, or call the police and notify them that this person is not registering accurately or not verifying their information accurately.
Okay. I do think probably a piece that plays into it was mom was saying that, he just stays here sometimes.
Mhm.
But I was like, wait, there's been a lot of unannounced visits now and he's always here. So, okay, I will do that. Thank you.
Yeah, no
Awesome.
problem.
Thanks. And Deb, I forgot about you. Deb, do you still have a question or was your question answered? And if so, you can unmute yourself real quick and that will be our final question.
Okay. You may have addressed this before, but if I understand what you said, somebody that is moving from another state into Delaware, um, and they've gone through the proper channels, they come into the state first as a tier 1 until the assessment is done. If How long does that take? Because they might be, tier
That's tough
3.
for me to say. It's a
Oh,
it's a court process, so
yeah.
we have to be notified, file the motion, it has to be scheduled for a court date, and then the motion has to be heard and then granted. So it varies.
Yeah.
Obviously, during COVID, things got really backed up because there
Yeah.
wasn't court happening as often. So there was a lot of motions that didn't get to be heard until after the courts opened back up. My understanding is that we are back on track and things move pretty quickly. Um, we get notifications every single day that people are moving in and they need to be tiered. And we're filing those motions and they're heard. At the time I was in the unit, they were being heard the first Monday of every month. They were hearing like 10 or 15 of them. But I think they might even be hearing them more often now because there's just to make sure that we're keeping up with it. But I will say, not now that we're not in the, COVID or a pandemic time where we're getting backed up, they are heard fairly quickly, I would say. But at the very least, we know that they are being monitored under tier 1. They can't just completely fly under the radar. So they are assigned a tier 1 and then they will be elevated once they actually need to be, or actually are assessed.
Are they ever prioritized? Do you have a sense of if they're really needing to move quickly to be tier 3 or it doesn't work that way?
Only within the discretion of the deputy who's in charge of tiering,
Okay.
and or the support staff that are in charge of that as well. If someone comes in and they seem to be someone that's a real priority, obviously they'll make that decision. But otherwise, it's just like kind of first come, first served. Every day we get a list of offenders that are moving in, and we draft the motion, sign the motion, submit it, and then it gets kind of heard in its in the order in which it's received.
Okay. Thank you very much.
Mhm.
Wonderful. So Kristina and Kelly, I want to thank you both so much for presenting today. We really, really appreciate it. And I want to thank all the CASAs that attended as well. So we will close this training and I wish you all the best of the rest of your day.